Welcome to Public and Private International Law, Chapter 9, Part 4. So what about Chapter 12 of the Swiss Code of Private International Law? What did you find out? What makes for a particularly arbitration-friendly legal environment in those provisions? Well, first of all, Article 176 defines the sphere of application of Chapter 12 in a broad way. Basically, Chapter 12 applies to all arbitrations that involve at least one party based outside Switzerland as soon as the seat of arbitration is in Switzerland. Article 177 takes a very liberal approach to arbitrability. It makes it clear that any pecuniary claim may be submitted to arbitration. Article 178 favors the validity of arbitration agreements. It makes it very difficult to invalidate arbitration agreements. For the arbitration agreement to be valid, it is sufficient that there is some written text recorded in any form whatsoever. And most importantly, paragraph 2 offers 3 alternative bases for establishing the validity of the arbitration agreement as far as legal requirements are concerned. According to Article 178, paragraph 2, the arbitration agreement is valid as soon as it complies with the requirements either of the law chosen by the parties for the arbitration agreement or the law governing the subject matter of the dispute, substantive law applying to the case, or third alternative, Swiss law. And it is entirely enough that the arbitration agreement is valid under just one of those laws. In the light of Article 179, paragraph 1, the parties are entirely free to agree on how the arbitrators are appointed, removed, or replaced. And paragraph 2 makes sure that to the extent to which the parties have failed to do so, assistance of state courts is available to appoint the arbitrators and set in motion the arbitration process. Article 182 grants the parties the broadest imaginable freedom in determining the arbitral procedure, which enables the parties to choose the procedural rules they deem to fit best for their business context. And paragraph 2 provides for the subsidiary rule that the arbitral tribunal defines the procedure in case the parties have failed to do so. Article 183, paragraph 1 makes provisional and protective measures available in arbitration. And paragraph 2 makes sure that the assistance of state courts is available in case of non-compliance by the party concerned with such measures ordered by the arbitral tribunal. Articles 184 and 185 provide for additional assistance by state authorities, especially with regard to the taking of evidence. Article 187 opens the parties the widest possible choice concerning the applicable law, and it even allows the parties to authorize the arbitral tribunal to decide ex equo et bono without any strict application of legal rules. In the light of Article 189, the parties remain also entirely free to agree on their own rules with regard to the decision-making process within the arbitral tribunal and with regard to the form the arbitral award should take. Finally, Article 190 makes it clear that arbitral awards are meant to be final and that appeals to state courts are available only on very limited grounds, which ensures that potential interference by state courts is reduced to a minimum. And this last provision on our expedition through Chapter 12 nicely leads us up to the next point in our program. And this is challenging an arbitral award. What exactly are the conditions to successfully challenge an award rendered in an international arbitration in Switzerland? First of all, the options are very limited. There is only one level of appeal, and the only competent authority is the Swiss Federal Supreme Court. The time limit is just 30 days from the day when the arbitral award has been communicated to the parties, and the Swiss Federal Supreme Court usually renders its decision on this kind of appeals within 6 months. Furthermore, the success rate for appeals against arbitral awards in international arbitration is very low. Statistically, it hovers around 7%. So it seems to be quite challenging to challenge an arbitral award. And in order to make for an arbitration-friendly environment, it has to be that way. Reducing the interference of state courts to a minimum makes sure that normally the arbitral award is final and puts an end to the dispute of the parties, which is what arbitration must be capable of if it is to offer an efficient way of solving disputes. This is why Article 190 defines the grounds on which arbitral awards can be challenged very narrowly. The arbitral award is final and it can be challenged only A, in case of an irregularity concerning the appointment of the arbitrators, B, in case of a wrong admission or refusal of its jurisdiction by the arbitral tribunal, C, in case of the arbitral tribunal going beyond the claims of the parties or not dealing with all the claims of the parties, D, in case of a violation of basic procedural rights of the parties, and E, finally, in case of incompatibility with the Swiss ordre public. And here you have the overall picture that shows you how limited the appeal options are. Based on what we discussed so far, let us now turn to comparing litigation and arbitration. What is better? At this point, I would like to invite you to take a piece of paper and list the advantages and disadvantages of litigation and arbitration with regard to the decision-making body, the proceedings, the availability of appeals, the time frame and cost, and the enforcement of decisions. And as soon as you are done, I invite you to move on to the next podcast, part 5.